All right, I'm going to go over the mental hygiene law quiz for Article 81. The first question is Mental Hygiene Law 81.02, and it is, which, if any, of the following are true? So, the court may appoint a guardian for a person if the court determines, and it lists three things. One, that the appointment is necessary to provide for the personal needs of that person, including food, clothing, shelter, healthcare, or safety, and or to manage the financial affairs of that person. Two, the person agrees to the appointment. And three, the person is incapacitated. And the answer is D, 1, 2, and 3. So again, they can appoint a guardian for a person if they determine, so they have to determine that the appointment is necessary to provide for their personal needs, and then of course it's always that and or, property management, and then the person has to agree to the appointment or they either have to be incapacitated. Question 2, Mental Hygiene Law 81.02. The court determination of incapacity shall be based on, and it's clear and convincing evidence, and it shall consist of a determination that a person is likely to suffer harm. Now, that is because on the answer key it just says suffer harm, but it's because they can't provide for their personal needs and or property management, and they can't adequately understand and appreciate the consequences of such inability. So again, court determination on incapacity, clear and convincing evidence, and it shall consist of a determination that the person is likely to suffer harm, and the reason they're likely to suffer harm is because they can't provide for their personal needs and or property management, and they can't adequately understand and appreciate the consequences of such inability. Now, question 3, 81.03, guardian means which, if any, of the following? So it lists 4 options. 1, a person 18 years of age or older, true. 2, a corporation, true. 3, a public agency, yes. And 4, in certain circumstances, a local department of social services, yes. So the answer is all of the above, which is choice C on the answer key. Question 4, Mental Hygiene Law 81.04. If after a hearing or trial, it is determined that relief under Mental Hygiene Law Article 81 is necessary, the Supreme Court and the county courts outside New York City shall have the power to provide relief under Mental Hygiene Law Article 81. And the options are 1, for a resident of the state, and that's true. 2, for a non-resident present in the state, that is true. And 3, a non-resident of the state pursuant to Mental Hygiene Law Section 81.18, which that section deals with foreign guardians. And that's when a person is not in the state, they're not a resident of the state, but they have property owned in this state. And so they've had a guardian appointed elsewhere for them. Question 5, Mental Hygiene Law, just to go back. So the answer for that was yes, all 3 of those things. Question 5, Mental Hygiene Law 81.11, true or false? If on or before the return date designated in an order to show cause, the alleged incapacitated person or counsel raises issues of fact and demands a trial of the issue, the court shall order a trial by jury thereof. Failure to make such demand shall be deemed a waiver of the right to trial by jury. And that's true. So they have to make that demand for a trial by jury either before or on that return date of the order to show cause. If they don't do it, that's it. They've waived their right. Okay. Question 6, Mental Hygiene Law 81.07. Upon the filing of the petition under Mental Hygiene Law 81, the court shall set the date on which the OSC is heard no more than 28 days of the signing of the order to show cause. And again, for good cause shown, the court can schedule it for a date less than 28 days, but they can't schedule it to be heard more than 28 days from the signing. Number 7, Mental Hygiene Law 81.09. At the time of the issuance of a order to show cause, the court shall appoint a court evaluator. The name of the court evaluator shall be drawn from a list maintained by OCA. Number 8, true or false? Any person for whom relief is sought under Mental Hygiene Law Article 81 shall have the right to choose and engage legal counsel of the person's choice. And that's true. And let me see if I can, I don't have the statute in front of me, so I might have to add or go back to it. But I think there's something in there where like the court appoints an attorney for them, like initially or something, but they have a right to choose their own legal counsel, and then as long as the court sees that everything, I guess, was done on the up and up, or there's no issue with the person that they chose, then that person can be their counsel and replaces whomever the court might have initially appointed to represent them. Again, I don't think that's even going to be something about that'll be on the test. But anyway, a person for whom relief is sought under this article has the right to choose and engage legal counsel of their choice. Number 9. Mental Hygiene Law 81.13. Unless the court orders otherwise, proceedings under Article 81 are entitled to a preference. And that is true. Regardless of what court it's filed in, these proceedings get a preference over other things on the calendar. Number 10. Mental Hygiene Law 81.13. A decision shall be rendered within 7 days. 7 days after the hearing, unless for good cause shown, the court extends the period for rendering the decision. And then there's another slight time rule that goes with that section that's not listed here, but also the commission shall be issued to the guardian within 15 days after the decision is rendered. So again, for question 10, a decision has to be rendered within 7 days after the hearing, unless for good cause shown, the court extends the period for rendering the decision, and then the commission shall be issued to the guardian within 15 days after the decision is rendered. Number 11, Mental Hygiene Law 81.19. All right, continuing with the rest of the Mental Hygiene Law quiz. We were up to number 11. So which, if any of the following, are eligible to be a guardian under Mental Hygiene Law 81? And it lists 4 options. 1, any individual over 18 years of age, that's true. Any parent under 18 years of age who is found to be suitable, that is true. And again, that's something I think might be important to know, because generally the courts never really let anything go on where a person's under 18. Usually the rules are always like 18 and over. But in this situation, it can be a parent under 18 who is found to be suitable. 3, a not-for-profit corporation organized to act in such capacity, that is true. And 4, with certain limitations, a corporation, and that is true. So that is all of them. And also good to know is that mental hygiene
legal service cannot be a guardian.
Shall not be a guardian. Number 12, Mental Hygiene Law 81.20, subsection 5, a guardian shall visit the incapacitated person not less than 4 times or more frequently as specified in the court order. So again, in order for them to have fulfilled their duties, they have to visit that incapacitated person not less than 4 times. 13, Mental Hygiene Law 81.23. At the commencement of the proceeding or any subsequent stage of the proceeding, the court may, upon showing of danger in the foreseeable future to the health and well-being of the alleged incapacitated person, or danger of waste, misappropriation, or loss of property, appoint a temporary guardian. Temporary guardian. So again, it's upon a showing of danger in the foreseeable future to the health and well-being of the alleged incapacitated person, or danger of waste, misappropriation, or loss of property. So on the answer key, both options were danger. There was something about a Will Robinson listed under it. I didn't know what that was. I looked it up. I guess it's from a show called Lost in Space. So number 14, Mental Hygiene Law 81.24. The petitioner shall, prior to judgment, file a notice of pendency if real property or any interest therein is or may be affected by the proceeding. Number 15, Mental Hygiene Law 81.30. Now this has to do with an initial report. So, not later than 90 days after the issuance of the commission to the guardian shall file with the court that appointed the guardian a report in a form prescribed by the court stating what steps the guardian has to take to fulfill his or her responsibilities. Question number 16, Mental Hygiene Law, point 31. Every guardian shall file a report annually in the month of May. So again, every guardian has to file a report annually in the month of May. And final question, number 17, Mental Hygiene Law 81.27. Within 5 days after the guardian has filed a designation and has filed a bond, unless the court has waived a bond, the clerk of the court shall issue a commission which shall state the title of the proceeding, the name, address, and telephone number of the incapacitated person, and the name, address, and telephone number of the guardian and the specific powers of such guardian. And 3, the date when the appointment of the guardian was ordered by the court, and 4, the date on which the appointment terminates if one has been ordered by the court. So again, within 5 days after the guardian has filed a designation and has filed a bond, unless the court has waived him having to file a bond, the clerk of the court issues a commission. And this is basically the thing that gives them their authority. It tells them the limitations of their authority, and it has all the information necessary. So it lists the title of the proceeding, the name, address, and telephone number of the incapacitated person, the name, address, and telephone number of the guardian, and their specific powers. So the specific powers of that guardian, and the date when the appointment was ordered by the court, and the date on which the appointment terminates if one has been ordered by the court.